Hello and welcome to today's analysis. Today I'm discussing the removal of a chief judge. Recall that recently the Benue State House of Assembly has been in the news for reason that they passed a resolution for the removal of the chief judge of that state. Following that resolution, the Nigerian Bar Association has condemned the removal and they have asked that every such step should be suspended. The National Judicial Council, the body that is saddled by the Constitution for the recruitment of judges and for the sanction of judges, they've also made a public statement that the removal of the chief judge of Benue State is rejected and that the person that is known by the that is known by the NJC as being the chief judge of Benue State has not changed. So they are equally asking that every action directed at the removal of the chief judge has to be suspended. This begs the question about who is right. Is it the Nigerian Bar Association that is right? Is it the National Judicial Council that is right? Is it the Benue State House of Assembly that is right? And more importantly, what is the provision, the proper procedure for the removal of a chief judge of a state? That takes us to section 292 of the Constitution. What does it say? The chief judge of a state, grand cadi of Sharia Court of Appeal of a state, shall not be removed except, note, by the governor acting on an address supported by 2/3 majority of the House of Assembly of the state, praying that he be so removed for inability to discharge the functions of his office or for misconduct or breach of the code of conduct. So the question is, has the Benue State House of Assembly not complied with this provision of the Constitution? Where have they deviated? Could it be that 2/3 majority did not support the resolution? If 2/3 majority supported the resolution, are they now wrong? Can we rightly say that they were wrong? Can we say that they have gone against the provision of the Constitution? That's the question now. Now let's look at the other arm of section 292 of the Constitution. It says that a judicial officer shall not be removed from office except in the case of the Chief Justice of Nigeria, President of the Court of Appeal, Chief Judge of the Federal High Court, Chief Judge of the FCT High Court, and other heads of federal courts. Note, by the President acting on an address supported by 2/3 majority of the Senate. So the simple implication of this provision is that this section supports the removal of the Chief Judge of the Federation, Chief Justice of the Federation, removal of the Chief Judge of the Federal High Court, State FCT High Court, and other heads of federal courts. But the section says it must be supported by 2/3 majority of the Senate passing a resolution and asking the President to so act. So the question is, why is the NBA sending a letter to the State House of Assembly? Why is the NJC rejecting the removal? Now, let us look at section 292 sub B of the Constitution. It says, in any other case, that is, aside the case of the heads of the courts, okay, the president or the governor shall not remove a judicial officer before the expiration of his retirement age, except he is acting on the recommendation of the National Judicial Council that the judge be so removed. This section means that the Constitution itself has created a dichotomy between a judge and the head of the court. Yes, the head of the court must be a judge, but there is a difference. These sections of the Constitution has clearly shown that there is a difference between there is a dichotomy between a judge, strictly speaking, and the heads of courts. Section 292 sub B says you cannot remove a judge from the office of a judge except the president or the governor is acting on the recommendation of the National Judicial Council. But is there any such provision here regarding the removal of the head of a state court? There is no such provision. There is no mention of the NJC here. Is there any mention of the NJC in the removal of the Chief Justice of Nigeria, President Court of Appeal, Chief Judge of the Federal High Court? That is, as regards the heads of the federal courts in Nigeria, you can see there is no mention of the NJC. The section only mentions 2/3 majority of the Senate. You can also see here, as regards the state, there is no mention of the NJC. All it says is that the governor can remove based on an address supported by 2/3 majority of the members of the House of Assembly. Like I said earlier, Nigerian Bar Association says you cannot remove. NJC says you cannot remove. And what is the reason they have said so? They are saying that the Supreme Court and the Court of Appeal has given interpretation over the years about how to remove the heads of court, and that in the judgment of the appellate courts, it is stated that you must pass through the NJC. That is the argument, that you must pass through the NJC. And so they are saying that the Benue State House of Assembly cannot remove the Chief Judge of Benue State if they have not yet passed through the NJC. They need to report him to the NJC. The NJC will sit, deliberate on his matter. If they find him culpable, then they will be the ones to recommend the removal. But like I said, none of that is in the sections that I have reproduced here. Okay? That means there's a problem. And what's my recommendation? My recommendation is that the Constitution of the Federal Republic of Nigeria needs to be amended. Amended. Just as you have mentioned the NJC as regards the removal of a judge, NJC should also be clearly mentioned as regards the removal of the heads of courts, be it state high courts, be it federal high courts or CJN or PCA, that's President of the Court of Appeal. This section of the Constitution, my recommendation is that it has to be amended to mention the NJC clearly, the same way the NJC has been mentioned as regards the removal of judges. In the meantime, everybody should take it easy. Fair hearing should also be accorded to anyone that allegation has been made against him. Until this recommendation, this amendment is made in the Constitution, I'm afraid we may have a repeat of what's going on in Benue State. Because even the Benue State House of Assembly is saying, NBA, you are interfering with our functions. NBA, we have done what the Constitution says we should do. This other one that you are speaking, we do not know. What we know is the Constitution, which is the supreme law of the land. But the NBA is saying, no, you cannot proceed because the appellate courts have interpreted this. That means it's a clear problem. There is an issue that I recommend that an amendment should be made as soon as possible to the Constitution so that when the removal of a chief judge is being contemplated, it will be seen on how to do it clearly, written in the Constitution. It mustn't be until you open to the books, the law reports, before you can see it. You should be able to see it clearly in the Constitution itself, just as you have seen NJC being mentioned in another section. But like I said, for the meantime, everyone should take it easy. For the meantime, fair hearing should be made to be part of the removal process. Everybody, take it easy, give fair hearing, and all that. Many thanks for watching this edition of the analysis. I do hope you have learned one or two things. What's your comment? Is the Benue State House of Assembly the party that has done the right thing in this case? Or is it the NJC? Is it the NBA? Who is right? Who among them is right? What's your comment? Drop your comment in the comment section so that together we can also learn from you as to what the true position is and also as to what should be the case moving forward. Many thanks.